Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Min Kim from our Edison, New Jersey office. Hi there, Min, and welcome.
Hey Ariana, good seeing you again.
Thank you so much for being back. We have a really important topic today. We're going to be talking all about DHS's proposed rule to replace the current H-1B lottery with a weighted-based selection system. So quite an important topic. Just a quick disclaimer before we get started. I'd like to remind you all that this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please comment them below or email us anytime at info@chug.com. Okay, Min, so in the interest of time, I'd like to get right into today's discussion. What is this that I'm hearing about USCIS changing how the H-1B cap lottery is administered? Is this actually happening? And isn't the H-1B cap closed for this year? So are we talking about these changes being implemented for 2026? What's going on here?
Right. You're absolutely correct in pointing out that the cap has been reached for this year. Just last month, USCIS announced that they have received enough H-1B cap petitions to reach the 65,000 number for H-1B regular cap and the 20,000 for U.S. master's degree exemptions for fiscal year 2026. So I suppose the absolute earliest that we're talking about in terms of any kind of rule change to the lottery selection process is for fiscal year 2027, which will open up in March of next year.
Okay, so you mentioned rule changes. Can you give us the latest update so that US employers can properly prepare for H-1B cap season next year?
Well, the latest update, I suppose that we're hearing is that Homeland Security has submitted for federal review a proposed rule that would alter how H-1B cap registrations are completed. As most of the audience might know already, the current system for H-1B cap online registrations and the small changes the agency has recently adopted, making the program a little bit more beneficiary centric, is that it's completely random, meaning that if a foreign national beneficiary, that beneficiary has an equivalent of a U.S. bachelor's degree or possesses, let's say, a qualifying U.S. master's degree, he or she has an equal chance of being selected in the cap lottery as compared to another foreign national with those, same or similar credentials. Thus, other factors such as occupation, the position's wage, any kind of educational attainment by the employee, those should not matter in determining the likelihood of having a cap number selected in the lottery. This randomized, lottery selection process is actually codified as an official rule, which means that USCIS must adhere to it. So if now the agency wants to deviate from this random selection process and instead choose a process that gives preferential treatment to registrations that include other factors such as wage offered, Homeland Security needs to change the rule first. And this is what they're seeking to do right now.
What about DHS? Where are they in this overall rule changing process? And should we be expecting an announcement on the part of this agency?
Right. I mean, thankfully, no. No announcement anytime soon. The rule is just starting out. A public notice was issued just last month, announcing that this proposed rule currently is with the Office of Management and Budget, or OMB for short. A rule submitted to OMB for review is typically the first step in the federal rulemaking process, or in this case, USCIS's attempt to change a rule that's currently in place that goes away from a random selection process to now a more weighted one.
Okay, and this weighted selection process, we're talking about weighted selection in terms of wages offered for H1 occupations, right? Or are there other factors besides the wage that USCIS will consider in determining who gets one of these critically important H-1B cap numbers?
Well, that's the thing. I suppose as of now, we don't know for certain what the weighted selection criteria will actually look like. Chances are strong that the wage offered for the position will be one of the more important components if not the only component that DHS looks to. But since the proposed rule has not yet cleared OMB review and has been posted for public review and comment, we cannot be absolutely sure what those additional factors will be regarding this new weighted selection process.
But Min, am I not right in saying that Donald Trump and this administration actually attempted to do something similar about 4 or 5 years ago in totally upending the H-1B randomized lottery process? And didn't that first attempt seek to use the wage as the selection criteria component?
Yeah, you're absolutely right about that. This isn't the first time that this administration wanted to alter how the H-1B cap selection process is done. In 2020, during the final weeks of the president's first term, Homeland Security actually finalized a regulation that would have essentially replaced the computerized H-1B lottery with a system that allocated H-1B visa numbers according to the Department of Labor's four-level prevailing wage system. That rule basically would have first distributed H-1B numbers to beneficiaries who were offered a wage that either equaled or exceeded a level 4 prevailing wage, which represents the highest wage tier, and then registrations would then have been selected in descending order thereafter, from prevailing wage 3 to 2, and finally to prevailing wage level 1. In that earlier rule, a computerized lottery would only have then been used if the number of total registrations for that specific wage level exceeded the number of H-1B cap numbers. So, for instance, let's say we have 90,000 H-1B cap registrations were filed by U.S. employers which disclose wages that were at least equal to a Department of Labor level 4 prevailing wage. Then a randomized lottery would then take place to choose a 65,000 regular cap number and the 20,000 master's cap exemption from that total.
So this means that all of the other H-1B cap registrations starting from level 3 prevailing wage to level 2 and all the way to level 1 would be shut out since enough numbers were received by USCIS for level 4 occupations. Is that correct?
Yep, that's exactly right.
And what happened with his first attempt by Trump in turning the H-1B lottery system on its head? Did it not survive in the courts?
It never really took off, to be honest. The administration simply ran out of time because this rule was posted for public review in the last few weeks of Donald Trump's presidency. So, when Biden took office, it wasn't a priority item for the changing administration back then and was ultimately postponed and eventually vacated by the federal courts.
But now here we are in 2025 in year one of Trump 2.0. So I'm guessing that running out of time is probably not going to be an issue for the administration this time.
It certainly appears so. As I mentioned before, the rule is drafted and currently with OMB for review. OMB reviews, they traditionally take around 2 to 3 months. So I would imagine that before the end of the year, the rule will be posted for public notice and comment, which should wrap up in a couple of months thereafter. I suppose all this is to say that there is enough of a runway here for the administration to implement this rule in time for H-1B cap online registration starting in March.
I know for some in our audience, March 2026 probably seems like an eternity from now, but I don't think I'm incorrect in saying that for larger organizations which have historically employed a rather large foreign national worker population, March isn't really too far away. Don't companies usually start ramping up H-1B preparations around the start of Q4 every year?
They do. Now, it all depends on the company. Some like to get a head start and get an evolving final roster of H-1B registration candidates, into the law firm that they might use to process those registrations around the end of every year. Whereas other, employers, perhaps they start, they wait until the start of the new calendar year to think about cap. But regardless, whatever the policy might be, and whatever timeline an employer uses to plan for, the H-1B cap strategy, no one's going to argue that getting a head start is a bad thing, especially with these monumental changes that are being contemplated by this administration.
So let's talk about this new proposed rule with more depth then. I know we can't say for certain that it's going to be wage-based, and we don't know the exact criteria that USCIS will use in the event that this rule is adopted and applied for next year's H-1B cap. But are there any takeaway points which you can share with our audience, things companies as well as foreign workers should perhaps keep in mind as we wait for this rule to go into effect?
Probably one of the main takeaways, in my opinion, is that this weighted selection criteria will likely use the offered wage, as we talked about, as one of the principal weighing factors, similar to what the administration attempted to do 5 years ago. But the audience shouldn't be surprised if it turns out that wage won't be the only component used. For example, a beneficiary's highest level of education can also potentially be used, and or some other combination of any kind of merit-based factor. The government, whether it be under Trump or even Biden, has long been in favor of moving away from a lottery selection process to one that is indeed merit-based.
But Min, how can you argue that a system that is wage-based, which awards H-1B cap numbers to ones who simply earn more than others, is in fact merit-based? Isn't this change simply awarding H-1B cap selections for those who have years and years of experience? And isn't it rather common that a software developer, for example, who has been in the industry for maybe 10 and 15 years, is going to be paid more than a recent college graduate looking for her first job? So isn't this wage-based selection process simply forcing the best and brightest international students out of this country because the only realistic option they had to remaining in the US and working in the form of an H-1B visa is now being taken from them?
That's absolutely valid, and I suppose it captures it really well. But this administration, they have a history of being antagonistic to foreign students. Just take earlier this year, there was a fiasco with ICE terminating the SEVIS records of F1 students. So it appears to me that this proposed change to the H-1B cap is sort of in lockstep with those efforts. The president at times has publicly declared his support to ensuring that the best and brightest study in the U.S. and continue to reside in the U.S. lawfully and contribute to our country's growing economy. But the actions by this government certainly might suggest otherwise.
You mentioned earlier that perhaps a foreign worker's education might be another factor that is used as part of this weighted selection process. Could you expand on that point for us?
Well, it should go without saying that the higher the educational attainment, the more likely a beneficiary's registration will be selected if this proposed rule does in fact consider a foreign worker's education. But I suppose the audience should also keep in mind that maybe a lesser focus issue is USCIS favoring beneficiaries who are actually educated in the US rather than those who are foreign graduates. What I mean by this is that there's been some open discourse and criticisms of the H-1B program in that the current setup allows certain mass filers of H-1Bs, let's say perhaps consultancy firms globally, to completing and filing hundreds, if not thousands, of H-1B cap registrations on an annual basis, just so that a lottery selection can be secured, despite those same employers not really having a specific client project for that beneficiary to start on or around that effective start date of the proposed H-1B employment. So, in other words, the employer might have really no intention of having the foreign worker start in H-1B status that year. But in the event work does open up in subsequent years thereafter, the H-1B registration and petition have already been filed and approved, and the H-1B visa is already in hand for that foreign worker to now quickly travel to the US and seek admission as an H-1B specialty occupation worker.
But there isn't anything wrong with that, though, is there? That's the program. So, if anything, those consultancy firms are acting shrewdly in securing those registrations and petition approvals instead of being forced to wait, whether that wait stems from, consular post delays or just built-in delay that H-1B employment cannot start until October 1st of every year.
That's true. That's absolutely true. And as you kind of point out, the program as it is set up, currently allows for that. So everyone is playing by those same rules. I suppose I'm just presenting the counter argument, which critics of the program are quick to point out, that the intent of the program was never for employers to file their registration so way in advance and secure an H-1B cap number and keep it in their back pocket, let's say, until eventually the need arises for the foreign worker to secure H-1B status and visit the US. The employment can't be speculative, and critics of the program are rather vocal in saying that this conduct of preemptively filing thousands and thousands of H-1B cap registrations is a pretense for speculative employment.
Okay, that's fair. But how does a US graduate versus a foreign graduate come into play then?
Well, oftentimes those foreign workers who are having those registrations filed for them in advance are outside the US and therefore are foreign educated. But if a foreign worker is in the US and has earned a US degree, this issue, in theory, is less of a concern because that same foreign worker in the US needs to maintain some kind of visa status, presumably H-1B visa status, in order to continue to reside and work here. So such a need does not apply to those outside the US since they don't have visa status by definition since they are abroad, and thus those folks can continue to wait until their H-1B employer is ready to bring them into the US on that next client project, whenever that might be.
Okay, I get it. Even for someone who might be an F1 student and working pursuant to her OPT, the F1 student needs to eventually start her H-1B employment and change her visa status so there's more immediacy rather than a consultancy company that just wants to secure a selected H-1B registration on the off chance that an eventual project might come up on a later date for a specific beneficiary. So the fact that the F1 student is US educated has less to do with her getting her education in the US, but is more about the fact that she's in the US already, and thus there is less likelihood for abusing the program.
That's correct. And once again, it's not really abusing the program as that is how the program is currently set up and run. But regardless, including U.S. education as a weighted factor will certainly incentivize U.S. employers to hire U.S.-based graduates rather than allegedly hoarding those cap numbers in order to distribute to their foreign workforce at a later time.
Okay, so we spoke about consultancy, but what about other industries? How do you think this revision to the H-1B cap selection process will affect other employers in other industries?
Well, I think it's safe to say that technology companies, especially those large ones, would likely benefit as they typically offer higher salaries. So, think Google, Facebook, Microsoft, companies of that sort. Relatively speaking, for the same occupations, those larger than life companies, they essentially offer double or triple the industry norms in terms of base salary. Having a weighted selection process which either singularly focuses on offered wage or takes wage into account would probably not move the needle in terms of whether those employers can continue to sponsor their H-1B cap beneficiaries. Also, I would think healthcare organizations seeking specialized doctors or researchers, they should also fare well. But universities, institutions, and smaller companies in the emerging tech sectors, they're the ones who might struggle. Traditional industries like manufacturing or retail, those industries, they need specialized employment, but don't necessarily offer high wages for those H-1B positions. They can also be significantly impacted.
What about employees and foreign students and workers? What are some takeaways for these foreign workers and beneficiaries?
Let's start with F1 students, since that was an example that we cited earlier. Recent F1 graduates, I believe they may indeed face increased competition in the job market for positions that were perhaps entry level before, but which employers might now need to beef up the selection criteria in order to set higher standards in justifying to pay higher starting salaries for those roles. And also, I wouldn't be surprised to see, a growing divide between students in STEM fields with advanced degrees versus students in non-STEM fields.
A growing divide. Can you share what you mean by that?
Well, it goes to the 24-month OPT extension for an F1 student who graduates with a qualifying STEM degree. Importantly, just because a foreign worker who is in F1 OPT status is in the US, it doesn't necessarily mean that she needs to automatically change her visa status to that of an H-1B worker that same year in which the H-1B cap petition might have been filed for her and ultimately approved. As those same consultancy firms do, any US employer, in fact, can actually petition for a consular process H-1B petition, meaning that the F1 student can continue to maintain her F1 status and work pursuant to her OPT and STEM OPT extension for up to 3 years, without triggering the need to change to H-1B status, and thus the higher wages that might come with such a change for an H-1B worker.
Okay, I think I follow you. It's because if an H-1B cap petition seeks to immediately change the beneficiary status from F1 student to H-1B, then with the change of non-immigrant status approved effective October 1st, the higher level 4 prevailing wage obligation, let's say, takes effect on October 1st. But if the foreign national maintains her F1 status and just started her 12-month OPT employment on her 24-month STEM OPT extension, then the H-1B employer can potentially delay the start of the H-1B status and thereby delay the need to pay the higher level 4 prevailing wage for the H-1B cap petition. I think we might have had a technical difficulty. We might have just lost Min, so we might be right back. If you guys are interested in us continuing this conversation, I don't know if we can get Min back today. Please let us know below and we can absolutely continue talking about this. Email us your questions at info@choop.com and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Thank you so much, everyone.